Hi friends, how are you all? I'm Shweta Gupta and today this channel of mine will be helping you out for your preparation of All India Bar Examination. In this channel we will be covering the sample papers for AIBE exam throughout the last 10 years, and I will be discussing each and every details about it, even if we can understand together what are the meaning of those questions. So friends, I am coming straight away to 2011 sample paper today. Part 1, Subject 1, Alternative Dispute Resolution, Category A. Friends, the question number 1 states that an arbitral tribunal should usually consist of. Before going to the choices which have been given, I will be telling you what do you mean by arbitral tribunal. Friends, arbitral means, or a tribunal, first of all I will tell you what do you mean by tribunal. Tribunal means the seat of a judge or one acting as a judge. A court or a forum of justice. A person or a body of persons having to hear and decide disputes so as to bind the parties. So apart from the normal court, we have an arbitral tribunal so that the things can be discussed easily. When the question is asking an arbitral tribunal should usually consist of, they have given 5 choices. Choice like a sole arbitrator, 3 arbitrators, an even number of arbitrators, an odd number of arbitrators, or an odd number of arbitrators, though if the parties continues with an even number of arbitrators, the parties are deemed to have waived their right to challenge a common award by such an arbitral on the ground that there was an even number of arbitrators. The correct answer is the last option, option E, wherein they have also tell the parties that they have the choice to take the number of arbitrators for their cases. So the choice E, which is saying the odd number of arbitrators, though if the parties continue with an even number of an arbitrator, the parties are deemed to have waived their rights to challenge a common award by such an arbitral on the ground that there was an even number of arbitrators. So friends, now question number 2. I will be going little quick so that we can cover quantum of question in this particular chapter of ours today. So question number 2, in an arbitration agreement, the arbiter, so they have given 5 choices again, have to be appointed by the court, have to be appointed by the International Chambers of Commerce, has to be Chief Justice of the High Court that has jurisdiction, may be decided by the parties, has to be formed a panel approved by the Law Commission of India. The answer to this question is have to be appointed by the International Chambers of Commerce. So friends, how will you understand and decide, and how you can actually learn these answers is by repetition. Only through that you can improve your learning curve. I will make these videos so that you can open this recorded form of videos anywhere and can learn this apart from your normal readings. So the answer to this is answer B, which has to be appointed by the International Chambers of Commerce. Then question number 3. An arbitration agreement is a condition precedent for a valid arbitration under the provisions of Arbitration and Conciliation Act 1996 with reference to substantive agreement between parties. So again they have given five choices for this. The choices which are there is the arbitration agreement has to be a separate agreement referencing the substantive agreement. The arbitration agreement can be a clause of substantive agreement. The arbitration agreement has to be separated, agreed upon by telex or email or in writing under section 7 of the Arbitration and Conciliation Act 1996. The arbitration agreement has to be a separate agreement registered with the High Court. The arbitration agreement has to be a separate agreement notarized by a notary. So the answer to this question is opinion C, or the choice C, which says the arbitration agreement has to be separately agreed upon by the telex or email or in writing under Section 7 of the Arbitration and Conciliation Act 1996. Now question number 4, friends. Under the Arbitration and Conciliation Act 1996, the rules of the procedure for a domestic arbitration can be chosen by the parties subject to the requirements of Section 18. This is the first choice. Second, can only be set by the arbitral tribunal, has to be presided by a court of competent jurisdiction, has to be as per the procedures set forth by the New York Convention for a Geneva Convention, has to be as per the procedures prescribed by the Law Commission. Answer to this question is choice C, which says has to be prescribed by a court of competent jurisdiction. Friends, if I will suggest you that you keep on revising this and understand the terms by Googling if you don't have the answer to a particular term or a legal term. So that's the way I go on. If I want to understand any legal term, I Google and I understand that. So friends, let me Google the meaning of competent jurisdiction here. Competent jurisdiction. And it says jurisdiction is a legal term for a legal authority granted to a legal entity to enact justice. So it's a legal term for the legal authority granted to a legal entity to enact justice. In federations like United States, area of jurisdiction apply to local, state and federal levels. What is competent court? It means the Supreme Court of India or the High Court or any tribunal or any similar judicial or quasi-judicial body that has jurisdiction in relation to issues relating to that project. So friends, I hope you are able to relate how we are trying to link all these legal terms with our question answers. So friends, this was category A, and now I will be coming to category B in the next series of this channel. I hope friends this is some importance to your preparation and it will give some kind of confidence to your preparation. I hope to see you back again. Take care. Have a great day.